welcome. My name is Margot Day. I'm the Policy Director at Accountability Counsel. Paco and Sue, is there, or anyone else from the GCF IRM, is there anything that you wanted to start off with? Otherwise, I'm very happy to get started. So just let me know.
Nothing on our side. Go ahead.
Wonderful. Thank you so much. Well, welcome everyone. Thank you so much for joining this webinar. Really excited to have this opportunity to have a discussion about important topics of accessibility and how to reduce the risk of retaliation for people who access grievance redress mechanisms. Let's see, we are really thrilled as Accountability Counsel to be a member of the GRAM partnership and are really thankful for this community of practice that helps ensure that grievance mechanisms are as effective as possible for the communities who need to use them. So just with a lot of excitement and appreciation, we're really happy to have everybody here today. It is my job to quickly run through the agenda and then kind of act as the facilitator or moderator through this and try to keep us on time. We have a lot to cover. We're going to have 4 different presentations. And so I'm just going to go ahead and introduce the objectives, introduce our speakers, and then turn it over to our first presentation. So the objectives of this discussion today is to talk about accessibility from the perspective of the communities who need to access these mechanisms. Accountability Counsel, who you'll hear more about later, works directly with communities who are impacted by investments and development projects who use accountability mechanisms or who use grievance redress mechanisms. So it's our responsibility here today to bring their voices to this conversation and talk about the accessibility challenges that we see, but also to provide some practical solutions for how to overcome these accessibility challenges, how to overcome the risk of retaliation. So we're going to highlight some of the barriers, talk about some practical solutions, and then talk about some ways that mechanism design itself can help address some of the barriers as well. Just as a reminder, we do have translation into Spanish and French, and so I will certainly try to speak slowly and give our interpreters some opportunity to be able to keep up with the conversation. And I encourage everybody to do that as well. And just as a reminder, this meeting is being recorded. So with that, you have the agenda in front of you. Our first presentation is going to be by Stephanie Omwaku and Rabi Chacha Musenda. Very quickly, Stephanie is a Senior Policy Associate at Accountability Counsel, where she supports Accountability Counsel's policy work to strengthen and create grievance mechanisms. She has extensive experience in human rights and access to justice work, including in Brazil and the Maldives. And prior to joining Accountability Counsel, Stephanie supported transitional justice and alternative justice systems work at an organization called the Public International Law and Policy Group. Rabi is a Communities Associate for Africa at Accountability Counsel as well. He supports African communities in navigating grievance mechanism processes. Rabi's human rights legal experience includes casework, community organizing and mobilization, human rights capacity building, strategy building, research and policy advocacy in both international and domestic settings. Prior to joining AC, he worked at Amnesty International Kenya as a campaign officer in the Safety and Dignity Program. Our next speaker is Sarah Dorman. She's a staff attorney with the People, Land, and Resources Program at the Center for International Environmental Law, where she supports communities negatively impacted by development bank projects and works to strengthen environmental and social standards at these institutions. She has a professional background in the areas of development, human rights, and international law, including working in Mexico, Egypt, Colombia, and Tunisia. And then we're very happy and thankful to welcome Victoria Marquez-Mies, who's the first Chief Accountability Officer of the European Bank for Reconstruction and Development's independent project accountability mechanism. She has extensive experience in development finance and in areas of governance, environment, and health around the world. So as you can see from the agenda, we're going to have 2 presentations, then pause for time for questions, and then we'll turn to the second set of presentations, and have questions there too. If anybody has questions during the presentation that you really want answered urgently, please put them in the chat. I'll be monitoring it, and we'll try to make sure that this is as much of a discussion as possible. We certainly don't want to just be presenting, and we want to try to have an opportunity for us to all share best practices and make sure that this is the most effective use of our time as possible. So really encourage questions and discussions. So with that, I will turn it over to Stephanie and Robbie to get started. Thanks, everybody.
Thanks, Margot. My name is Stephanie Mwaku, and Margot, thank you for that introduction. So I will now introduce Accountability Counsel. So we are an international civil society organization or non-governmental organization, and we have worked with over 50 communities around the world to navigate these accountability mechanism processes, whether they're at the multilateral development banks or bilateral donors. We have a communities team that works directly to support these communities through these processes. I'm with the policy team that works to strengthen the accountability mechanisms and also create new mechanisms so that there's a strong accountability ecosystem. And we also have our research team that researches trends across this space. Because of our experience, we're really delighted to discuss this topic with you today, and we are open to follow-up conversations, and we'll share our contact information later on in the presentation. So just to jump into it, what do we mean by accessibility? I have on the screen the definition from the UN Guiding Principles on Business and Human Rights Effectiveness Criteria. So accessible, being known to all stakeholder groups for whose use they are intended, and providing adequate assistance for those who may face particular barriers to access. But in practical terms for us, we look at it as essentially, do communities know that the mechanism exists, and do they feel comfortable and able to use it? So a key question is, why is this important? And to just provide some data on this, the vast majority of projects or business activities are not subject to complaints. And I'll give you an example from the International Finance Corporation. So in 2020, the IFC financed 282 long-term investment projects alone. However, its accountability mechanism, the Compliance Advisor Ombudsman, has only received 365 complaints through 2020. So as you can see, most projects are not subject to a complaint. But from a community standpoint, we want to make sure that that's not because, some would say that it's because the projects are doing well and there are no negative impacts, and so we don't have to really worry about it. But we want to make sure that there are not actually negative impacts happening, but communities do not know about the mechanisms or have barriers accessing them. And then if you look at this chart that I have, I just want to show you some data from our Accountability Counsel, which is a database of all the accountability mechanism complaints over the last 25 plus years. And accessibility is also important for communities once they enter the complaint process.
Puedan, digamos, acceder al mecanismo de reproducimiento. De los 1,395 reclamaciones,
31.5% of them were ineligible, and 23.6% of them did not go through an eligibility determination, which probably means that they were not even registered from the beginning. So you see that these may be filing complaints, but they don't have the information or the ability to file an eligible complaint given the requirements. And so just wanted to provide this snapshot of what we mean by accessibility. And I'll now turn it over to our colleague, Robbie Chacha Mwasenda, who will discuss practical examples of these accessibility challenges.
Thank you so much, Stephanie, for that great introduction. In my presentation, I'm just going to break down some of these challenges into 4 parts. So the first is with regard to information and communication challenges. And then secondly, I'll do a bit around the challenges due to cultural context in some of the cases that we've had. And then thirdly, I'll go into the challenges with technical filing requirements that are needed by communities. And then lastly, I'll go through some COVID-19 related challenges that have come up because of that. So when we start with the information and communication challenges, particularly, I think there's so many of them, but just to summarize in a bit for this particular context is, I think the first is with regard to communities not being aware of the availability and the processes of IAMs, or how to access some of these mechanisms. And then secondly, the requirement to submit complaints in specific languages has been a challenge for some communities. And then thirdly, complaint communications require significant time and resource investment for communities and their representatives. And I think just to talk about the first challenge, we had a case that we just filed recently in Uganda where this community has been affected by the project that's financed by the World Bank for about 7 years, and they were not aware of the availability of the inspection panel as a mechanism to complain to until just recently when they learned about that from a local civil society organization. So that in itself, and when they learned about it, it was an aha moment for them, and trying to ask how they can sort of reach out and complain to this extent. And then secondly, because of the fact that they were not aware of it, it became very difficult for them to take stock of the harms that they were facing in the context or to put together a complaint. So that has taken quite a while to find and put together. And so in terms of solutions, I think IAMs should play an active role within their institutions to ensure complaints options are communicated to affected people at the point where the projects are beginning. And I think throughout the project process, from project planning to implementation, communities should be aware of that, and that is a place mechanisms could play a huge role on. And then secondly, an affirmative outreach events by mechanisms, which I think is something that's already coming up, but I think there should be more of that specifically to communities that could be affected either presently or in future. And then thirdly, ensuring communication between mechanisms and complainants is as easy as possible, including communicating in local languages and accepting complaints in any language that this community would understand. And then recognizing the importance of working with local civil society organizations, because these are organizations that the communities trust and can go to even when the mechanism is not on the ground to sort of assess what's going on. And then there's an element of seeking out local consultants to build trust effectively. And in this, I'm thinking about the element of getting translators that are from the area and would be able to translate and communicate on some of these things. And then in terms of the second challenges, I'm told that translators are having a hard time, so I'll try and slow down. And then secondly, on challenges due to cultural contexts. So on challenges due to cultural context, I mean, most of this, I have seen some of this come up in our cases in Africa, but also the cases we have in Asia have had a bit of the cultural context challenges that come up. So the first challenge is in terms of societal norms that present barriers to women or minority groups within a community, making their concerns heard. And this is because of the patriarchal natures of some communities in terms of men speaking out on behalf of the communities. And so you leave out a huge part of women and minority groups being able to present what their opinions are on this. And then secondly, social hierarchies create division or increase security challenges, especially if those raising concerns are not the most powerful groups within a community. So you find a lot of reprisals coming up because of that cultural hierarchical nature of communities in that context. And so in terms of solutions, the first is, for mechanisms to take a flexible approach to issues that come to light after the initial complaint filing, because some of these issues come after the complaint filing and they were not maybe asked for clearly within the complaint. And then secondly, being aware of the likelihood of cultural norms and gendered hierarchies within communities and approaching complaints with such knowledge so that you're able to sort of fill those gaps. And then thirdly, in cases with complicated community dynamics, being patient with extra efforts to understand the case, including through field visits. And I think this is where local CSOs and activists come in to sort of support some of those dynamics and to point them out. And then lastly, considering issues that come up through the course of an IM investigation or conversations, even if they were not raised in the initial complaint filing, so that you're not missing out on events that are happening as and when the complaint process is ongoing. And then in terms of the technical filing challenges, so with this, I think the main one that I have seen, particularly in my work, is so we had a case recently last year in Tanzania about an education project funded by the World Bank, but because of the security situation in Tanzania, we were not able to file the complaint because it needed requesters, and some of these were families or girls from very vulnerable families. And so because of that, we're not able to file. And I think this presents the element of filing anonymously and just having a very minimum requirement in terms of who is able to file, because that can be a bar sometime and a challenge. And then secondly is the statute of limitations, where, for example, as I spoke about the Uganda case, for example, they learned about the process after 7 years of being affected by the same project. And so we're lucky that the project hadn't closed yet, but if it had closed, then they wouldn't have the ability to raise a complaint in that context. And then lastly is on parallel proceeding rules that have become a limitation for communities to use different strategies to sort of get justice, both local and international. And so in terms of solutions, one of the things to think about is, right now in the context of security, and this is increasingly becoming difficult even in the COVID-19 situation, is allowing communities to file anonymously on the security element or on the basis of security. And then secondly, creating eligibility rules that are easy to meet and simple to understand for communities. And then lastly, having a more flexible statute of limitation to account for communication challenges and where there were gaps in terms of information could be the solution. And then lastly is COVID-19 related challenges that have come up maybe over the past year with regard to mechanisms. So in terms of COVID-19 challenges, and I think this is a huge learning point, and we're still learning on creative ways to sort of fill the gap that COVID-19 has presented. And the first is, the lack of technological access and restrictions on in-person communications. And this has been a really difficult one, especially when you're dealing with a very local community that doesn't have access to maybe phones or internet. And so it becomes difficult to reach out to them and console them and have communication with them. And then secondly, curfews and gathering restrictions present an additional security risk. And a good example for this is, in our case in Uganda, because of the lockdown restrictions in place now, it's very difficult to have a meeting with community members, before maybe in the afternoon when you need to sort of speak to them, and that is after they've left their places of business and can then have time to focus on that. So it becomes difficult for you to meet with a group of community members, and it's because also of the potential risk of being arrested for meeting together for the purposes of coming up with a strategy for their case. And then lastly is with regard to travel restrictions that can prevent complaint processes from moving forward while projects and the impacts related to those are continuing. And for this, our case in Jharkhand is a good one because while the complaint process has stalled, the project in itself is still ongoing, which is still potentially a risk for community members. So in terms of solutions, I think mechanisms should have a little patience and flexibility in terms of and partnership in finding creative solutions. And I think this is where local civil society organizations and the communities themselves come in to play an important role. And then secondly, acknowledging the connection between COVID-related challenges and security concerns for the community, and playing a very central role in making sure that the safety and security of these communities and their activists is taken into account. So that's all I had, and thank you very much.
Thanks, Robbie. We'll further discuss some of these challenges through a case study concerning the Caracal Industrial Park in Haiti. It was a park financed by the Inter-American Development Bank. And so the Caracal Industrial Park is a garment manufacturing facility, and it was constructed on 250 hectares of the most fertile agricultural land in Haiti. And to build this park 422 farmers were suddenly displaced without notice and without a resettlement action plan, losing their primary source of income and food security. And this is 422 farmers, but this represents over 4,000 people affected. And so they received some compensation, but that was long delayed and primarily cash, which did not restore their livelihoods and was inadequate to address the harms suffered. And I'll actually share a short clip of a video so that you can hear from the communities themselves. So let's see.
Nord-est, nos affaires, bananes, manger, etc. Que yo vin pour yo vin mettre béton sous l'île là. Nous avons pas d'industriel là qui fait nous plus gros habits qui gagne pour le département nord-est parce que l'autre côté yo te
passé sous l'île. Mais elle a passé, yo mettez l'électricité à pied devant. Terre, ce sont des terres. Depuis que la pluie, de vous planter ton bagage, depuis que je viens de la pluie, c'est pour faire. Parce que terre aussi tellement vivant. De pousser planter rapide. Mais c'est comme ça, moi, ça sont politiques. Côté qui fait jardin, c'est là, on prend directement pour faire pas là.
Donc, Caracal, c'est quoi?
Okay, so you've heard about some of the negative impacts that have come from this project. In 2018, the communities filed a complaint with MISI and decided to engage in a dispute resolution process with the Inter-American Development Bank and the Haitian government. After several dialogue meetings, the parties signed an agreement in 2018. You can see some of the positive outcomes of the agreement, including new land and technical support for farmers. I also want to mention that the communities had organized themselves into a collective and were very active. The Haitian organization Action pour la Reforestation et la Défense de l'Environnement, ARED, and Action Aid Haiti also supported the communities in addition to Accountability Counsel. And so, as you can see, there was a positive outcome of this dialogue, but I also want to highlight some of the challenges during this dialogue process so you can understand what the communities were facing and also how the mechanism and advisors and the communities themselves were able to navigate some of these challenges. And also, given the current challenges in Haiti, I want to just acknowledge that there have been several challenges to the implementation of this agreement, but the parties remain committed to implementing the agreement. And so the accessibility challenges that came up during the dialogue process, one of them is language and literacy. And so French and Haitian Creole are the official languages of Haiti, and some assume that most people speak French in Haiti, but that's not the case. And so it was important to have interpreters available and documents translated into Haitian Creole. Additionally, although Creole is the first language for the community members, not everyone had a high level of literacy in the language. And so this is not an assumption that you could readily make that everyone would be able to read documents in Haitian Creole. And so Accountability Counsel, as advisors to the community, our research team developed a tool called Zoiseau that allowed us to connect surveys using voice messages through local phones. This also helped gather information from community members who did not have internet access. Another challenge is financial challenges. Although there are technically no costs to file a complaint with an accountability mechanism, oftentimes participating in these processes can have costs that limit the ability of communities to fully participate in the process. In Haiti, the dialogue meetings were held at a local university, which required the community participants to arrange transportation to the meetings. Understanding the financial constraints of the participants, MISI, the mechanism, covered the cost of transportation. And so one of our recommendations is that all mechanisms should understand and plan for these costs as a minimum for these processes. Additionally, being farmers, most of these participants had to take care of their agricultural responsibilities earlier in the day, so in the morning time. These dialogue meetings were thus held in the afternoon to make space for these responsibilities. So small adaptations like that can really make a difference. With COVID came challenges around ensuring that progress could continue to be made in the implementation of the agreement. MISI, the mechanism, tested out different systems to make sure that parties could still participate in monitoring meetings and that interpreters could provide interpretation. Because community members lacked internet, MISI was actually able to arrange with the industrial park to let participants use the park's resources so they can participate in virtual Zoom meetings. They have also invested in technology to allow them to add participants by phone to conference calls when, for example, it is not possible to gather people in one place because of COVID restrictions. And this is not to say that all accessibility challenges were solved in this case, but these examples demonstrate how being mindful of challenges can make a real difference. I also want to emphasize the importance of mechanisms respecting a community's right to representation and advisors. While the communities in Haiti were effective advocates for themselves, the local and international advisors in this case provided specific expertise that helped address power imbalances. And so I will stop there, and I'll now turn it over to Sarah Dorman from the Center for International and Environmental Law.
Thanks, Stephanie and Robbie. And Sarah, please feel free to take your full 10 minutes and I'll make up for the time at the end. And then I see that there's already some questions in the chat and a couple answers in there as well. We'll make sure that we turn to those right after Sarah's presentation. Thanks.
That sounds great. Thanks, Margot. I will first introduce myself and CL a little bit in more detail. My name is Sarah Dorman, and I'm an attorney with the Center for International Environmental Law. And for much of the last 3 decades, CL has been closely following the development finance space. CL was even instrumental in the creation of the inspection panel over at the World Bank in the early 90s. And we've been following various policy and mechanism developments ever since. So it really is a pleasure to be continuing the conversation today with all of you. And I would like to focus my comments just on a few reflections about the critical topic of reprisals. And this is based on CL's experiences accompanying a number of communities as they have worked to engage with the accountability mechanisms. And so when we talk about reprisals or retaliation, it's important to note that we are referring to really any detrimental act that can be taken against someone in the context of their engagement with an accountability or grievance mechanism. And of course, this can take a variety of forms. Unfortunately, in our experience, we've seen that this can take the form of threats, smear campaigns, as it says on this slide, intimidation and harassment, as well as criminalization, and even escalating into physical violence. And so today, I would like to share one experience that CL has had accompanying a community from Nicaragua. And in this community, the affected community members had for many, many years spoken out against the negative impacts of a gold mining project in their community. And as a result of having spoken out about this project, they faced numerous threats on a repeated basis, including harassment, surveillance, and even criminalization. And since the IFC, the International Finance Corporation, had an investment in this project, several community members with CL's support were able to file a complaint with the CAO, which is of course the accountability mechanism at the IFC. And one of the issues that was flagged early on and even in the complaint itself was this fact of the situation of reprisals and retaliation. And it was noted in the complaint that several community members had even faced criminal accusations as a form of intimidating them in this context. And so this is something that the CAO took into account from the very outset of dealing with this case. Then, unfortunately, around the time that the CAO carried out its site visit to the community, reprisals escalated once again. And so in this context, both before the CAO arrived and after CAO personnel left, national police, dressed in full riot gear and heavily armed, descended on the community. And this was very clearly identified as an attempt at intimidation and specifically targeting the people who were meant to meet with the CAO during this site visit. Now, I want to mention that the CAO did take a number of precautions in planning for this site visit, and it was in very close contact with the complainants in this case. And they even asked if they should be carrying out a site visit at all, given the possibility that a site visit could exacerbate the situation of reprisals in this situation. And in this case, the complainants did want to go forward and they wanted a site visit to occur. And so the CAO, of course, did carry out this visit. Now, several months, about a year, I believe, after the CAO began processing this complaint, the IFC itself decided to divest from this project. And this was seen as a really positive step, of course, from our community partners who had been opposing this project. And at the same time, the IFC did not issue a public statement about its decision to divest in this case. And that left our partners in Nicaragua in this really difficult situation of deciding whether to ever speak out publicly about the fact of the divestment, because it was foreseen that if they did so, they would face another wave of retaliation. And so our partners waited for several months, and we waited along with them as they decided whether to issue any statement about the divestment. And finally, at the end of 2019, one of the community leaders did decide to issue a public announcement about the IFC's divestment. And unfortunately, retaliation followed very swiftly. Within days, police had raided his home, physically and verbally harassing family members who were present at the time. And thankfully, this community leader was able to flee his home, but unfortunately, he has not been able to return ever since for fear of his safety. And one of the issues that made this really challenging was that the CAO case at that point had already been closed. And so unfortunately, the community members were left in an even more vulnerable situation because essentially no entity at the bank was actively monitoring the situation at that point. So this leads me to a couple of lessons that I wanted to draw out from this case. And these aren't meant to be comprehensive recommendations by any means for an approach to reprisals, but rather just some reflections from our partners and items that we've identified as important from this experience. And so the first is that trust and consistency really are key. In this case, our partners had developed a strong relationship with the first person, the first point of contact at the CAO that they had interacted with. They felt like they had gotten to know this person and that person had gotten to know their story. And then when the case was transferred to the compliance unit, our partners were concerned that that relationship would no longer be followed up on. And so our recommendation would be to have a consistent point of contact that can deal with these issues of reprisals so that complainants know that there's at least someone that they can reach out to, someone identified, and someone that can respond accordingly if they do face emergency situations. The next point really can't be overemphasized, and that is that prevention is essential. And I'll just highlight a couple of reflections here, noting that we'll be getting into more concrete recommendations in a bit. But the first is, of course, that confidentiality can be an important tool to protect complainants. That wasn't what the complainants in the Nicaragua case wanted, but it is important to note as an option. The next point is about how important it is to really analyze reprisals risks every time a complaint is filed. And that should include both the local and regional context. So in this case, there were very well documented patterns of widespread corruption, as well as government intimidation of media and civil society in the country. And at the same time, it was really important for the CAO to know the specific history of police harassment and criminalization of the community members who were involved in the specific complaint. The next point is about the need to coordinate very closely with complainants to address their concerns. And that's related to this next point about actively monitoring the situation and returning to the conversation on a repeated basis. And that was seen in this case with the CAO coordinating very closely with complainants at every step of the way. Finally, on this point, it was important in this case for the complainants that CL was involved as an organization accompanying the complaint, and we were informed and able to provide input as another pillar of support for communities at risk. In addition, of course, responding to reprisals is another crucial aspect that should be considered. And this can take a number of forms. Just from this case, one thing that could have been useful might have been a public statement. And that is because public statements can provide complainants with an extra layer of protection so that they're not the only actors that are speaking out about projects. And public statements can also signal to actors that might be perhaps responsible for reprisals that the mechanism is aware of the situation and that they are monitoring. And then finally, ongoing monitoring of reprisals risks really is critical. And based on this case experience, we would note that these risks can continue even after divestment in some cases, and even after the formal closure of a case. And so our recommendation would be that to the greatest extent possible, this monitoring and follow-up continue even after formal closure of a complaint. And in closing, I wanted to share a few additional resources, and we can share the slides, I believe. There are links here to several. But I did want to note that a lot of work has been done on the issue of reprisals already, both by the accountability mechanisms as well as by civil society to document patterns of retaliation in this context and to share some recommendations. And I did want to flag that other institutions have been grappling with these issues for many, many years. And so I've included here several comparative approaches from the United Nations just by way of example. And I'll leave it there for now, but thank you again for the invitation to be here, and I look forward to the discussion.
I was tasked with trying to present a more practical toolkit of what can we do to promote a more accessible mechanism. And I think all the presentations have actually given a lot of coverage to what are the challenges for complainants to reach mechanisms, but not only that, to ensure that all through the process, we actually remain accessible. And so I will cover some things. I'm trying to make this presentation short so that we can actually go to questions, which might be more relevant to you. And please, I offer my availability at any time to help other mechanisms or others trying to set up a mechanism on what has been my practice with my team, both at the IDB, at MISI, and now at EBRD, at IPAN. I'm happy to share that as well as what we have learned from the network of accountability mechanisms, where I was the first secretary. We have already seen this in Margot's slides, but and Stephanie's, but I'm setting the bar for mechanisms on the effectiveness criteria set by the UN Guiding Principles on Business and Human Rights. And among them, the one I'm going to touch on today is the need to be accessible and to challenge ourselves on ensuring that we're really accessible, which means putting yourself in the shoes of a complainant or a community that is trying to reach out. So the first thing on accessibility, according to the UN Guiding Principles, is being known to all stakeholders for whom we're supposed to be catering for, and provide assistance for those who face particular barriers to access. So if we think about this in this sense, I wanted to go into what does accessibility mean in practice. And I'm sorry, because I put on a number of cartoons, although this is a very serious matter, as well as the reprisals issue, because we have to really test ourselves if we were really trying hard to be accessible. And I set a series of questions to guide my presentation, but first of all, do we really know if the communities we're catering for in the countries of operation where our bank or our institution works are aware of our existence? And I want to go even further than that. What we need to know about a mechanism is not only that they know about the mechanism, but a step removed is whether they know that the institution we work for is funding that project, and what are the requirements that have been set for that project from the funding institution. Communities do not know about us, and obviously there's a reticence from institutions to raise awareness about the existence of a mechanism for fear of numerous complaints coming to us. So if you're thinking of doing any outreach, always think on how you're going to present so that people understand what is it that you're presenting and being accessible. What kind of information it is, what they need. Don't assume anything. And even when talking with civil society organizations who actually help us promote our existence and raising awareness, start from the very basics of what your institution does, and that also helps guide how they can use the mechanism as one of their tools in advocacy, in raising issues, and understanding the scope of what we do. The other thing is, do they know how to reach you? This is important because most of us are nowadays working through email and technology, but it was mentioned in previous presentations, we cannot assume that everyone has access to technology, or how can they really go into a website and send you an email? This is also a relationship that means that you're building trust on someone. You don't know who that person is. You don't know how they're going to respond. You don't know what language they're going to respond in. And that is important. So do a brief review of which countries, which places are you operating on? Is there any way you can understand what is it that reaches them best? Is this social media? Is it a website? Is this postal service? Is it a phone? And then try to devise any kind of outreach to suit those needs. Then the other thing, and I think it's been said numerous times, is does your procedure establish a lot of requirements that become barriers to access? And in this mechanism have two things that have to consider. Sometimes we're only implementers of a policy or procedure that is given to us to implement. Sometimes we have a say in those policies or procedures. So in MISI, in IDB, and I'm very happy to report, thanks to a Twitter from Accountability Counsel, that we had strong requirements that were barriers to access. One of those has finally, after years, being deleted from the requirements, which was also affecting another case that CL was following in Chile. So if your requirements to access the mechanism, to accept a complaint, are so numerous, so complex, that it's easier to get to heaven than to get to the mechanism, then you're not accessible. If you cannot have a say on that, but you can have a say on how you implement and how accessible you try, even complying with your policy, but reaching out to communities, making them understand what are the limitations and guiding them, this can be counterbalanced a little bit. On the other side, if you don't write the procedures, please take care of ensuring that you're not putting barriers to access just because you don't want to hear complaints or receive complaints at any one moment, or you or your institution. The other thing that we try to do on accessibility is, does it require an expert to understand it? I think civil society organizations do a wonderful job. I think legal representatives particularly do a wonderful job helping communities engage with us, but they shouldn't need anyone to engage with you and understand what's the process. If they don't understanding, it's because you as a provider of a service for them is not simple enough, it's not clear enough, you haven't really tested the way you engage with them in your communications. Get away from technical jargon, make it very simple, make it so that any community in any country where you operate really can understand this and test whether this is happening or not. The other is, how do you engage with complainants? I am someone who likes to engage in person. I don't like remoteness. I don't like this. I'm sorry not to be able to see you. But basically, even if our way of receiving a complaint is through email, don't continue that communication that way as the only source of communication with them. Both at MISI and at IPAM, we have a standard that in 2 or 3 business days, we're calling that person to listen, to understand what are the issues, to let them know that we have their complaint, and to guide them to the process. Then, what kind of language do you use? For the banks where I have worked, I am now in London, and the other one was in Washington, even though we cater for Latin America. People tend to set even barriers that don't exist. And they would tell me, well, we don't want to talk to a lot of American people. And they didn't know that we actually, there was a diverse group in the team that could speak their language, that they didn't need to speak English, that they could access us. Having said that, taking Stephanie, for example, the thing that she mentioned, our Haiti case, the complainants only spoke Creole, Haitian Creole, not French. And we had materials in French, but that didn't work at all. So we had to cater for those. And nowadays, I am operating under 39 countries of operation, where I have to cater for the language of each one and not think that they're supposed to be knowing English or Russian or German. So this is important. How do you ensure that they do not stop contacting you because they think you will not respond to them in your own language? And once they start communicating in the language, it's a standard. You keep on communicating with them in that language. That might take more processing, but that is what you do. You provide interpretation, you provide translation. Then, are your reports easily accessible and understandable by communities? We tend to hide behind a lot of jargon and technical jargon, and that is also not being accessible. So also test your materials and see if anything is being understood. I usually test my materials with either my father or my husband, because that way they don't know anything about what I do. And that if they understand, then I know this could be understandable. Then the issue on accessibility, and I will talk more about reprisals, is it safe to approach you? And there was a question on anonymity, and most mechanisms do not receive anonymous complaints. I was for a time engaging with the Caribbean islands, and they said, you will never receive a complaint from us because we're so small that we fear that even with confidentiality, we're not sufficiently protected, not only from the government or a client, but from our own neighbors in the community who are in favor of the project. Anonymity can work usually only with compliance, but it's important that we are catered to address harm to people. And so this is not a whistleblower approach that we're getting. And sometimes with anonymity, you would get that. So usually we do not accept those. But there's cases where, for example, in my mechanism, we accept complaints from non-affected organizations. If they, and there was this, someone was presenting this case, if the community cannot approach because of lack of safety. Then if we talk about going into reprisals and how do you ensure a safe environment to present a complaint? You want people to voice their concerns, and therefore they should be able to do it safely. Confidentiality is one way to be doing it, but I think it's important to understand a series of things when you have to address risk of reprisals. And what is happening out there, I just was in a webinar 2 or 3 days ago, where we continually see a growing of killings in human rights defenders everywhere in the world. This was very much focused on Latin America. As you can see, that's the second bar in that image. And basically, there's no more information that could be drawn publicly. So it doesn't mean that it's not happening, but rather that it's not reported. Progressively, the civic space is shrinking. And I was just reading, for example, in Kyrgyzstan, just passed a law restricting civil society organizations by demanding information, demanding to know how they're funded, etc. The same has happened in Russia, The same is happening in my own country, in Mexico, where now there's a law that's about to be passed where civil society organization employees are to be considered government employees because of the amount of money they receive from the government. And that means that they're further constraining the capacity of civil society to do their work. They're constantly harassed by the state in almost every country nowadays. And we also have that political divisions, economic downturn, civil unrest, and COVID-19 have been seen as reducing the capacity of communities to raise their voices. This is something we have to learn, and therefore we have to work on that, because having a mechanism that appears to be accessible but doesn't consider these issues and the countries where it's working is not doing a good job in accessibility and ensuring the safety of their complainants. So in practice, most of the policies nowadays are including some sort of statement on addressing risk of reprisals, but that doesn't allow the mechanisms to effectively implement safety measures and establish what should it be done to engage safely with their complainants, to visit countries safely, to do outreach activities safely. So for me, I'm going to pass through a number of points, and I'm happy to respond to that. Any questions is you have to understand the context you're working in, both the regional and the local context. And for that, you don't need a lot of money. You don't need a lot of experts. You need a Google search in the right sites to understand where is it that you're operating. At the same time, we tend to also do a lot of research on the clients that are now subject of a complaint, particularly for the private sector. Is this a repeat offender? Are there other mechanisms that have raised the issue, some things not going right? Then you start getting an assessment of where you're working. And that assessment also includes not only people raising the issue that they fear reprisals, but understanding the importance of the project to the country, even if it's a private sector project, how concerns are voiced in that country, whether that is impacting more vulnerable communities like say, LGBTQ communities or women, and therefore these groups do not have less of an opportunity to voice concerns, considering the environment they live and the context where they live and the laws that they have. So the first thing that we do when we get a complaint is really understand the context you're working. And one of the challenges, and I share with you this, because 5-6 years ago, no mechanism was talking about these issues, but also no multilateral bank was talking about these issues. And now we are. It's become such a big problem. So you don't come equipped with the capacity to do it. So train your team, train every member of your team, engage those that are experts and ask them to train you. And do this in a recurrent manner, because it is a big problem, it is a big issue, and most of the time the teams are not really aware of how to deal with these things. Produce a protocol, and a protocol is only as useful as you can really implement it. If your procedures and your protocol do not speak to each other, this doesn't work at all. So even a statement, there's no value in a statement saying you have zero tolerance for compliance, for reprisals, if those doesn't go further than posting it in your web. What does it mean for you that you do have zero tolerance? What does it mean for your institution that they have zero tolerance for that? That has to be in your procedures, establish clear, practical measures of what you can do and what you cannot do to keep your community safe, but also your team safe, or anyone you engage in whenever you are managing a case. Share the burden. I am very reluctant to think that mechanisms are the only ones responsible within their institution to address this issue. So Your institution has to have a policy, has to have a partner, and they're actually the ones that have the power to engage with the governments or with a client and tell them that this is not acceptable. You can establish measures, but you have to share that burden with the institution. You also need to have partners in the ground that are experts in managing this, particularly when you have situations in which your community might be so much at risk that you need to have someone to help them out, and you cannot do that 1,000 kilometers away when you're in a mechanism, and you're not equipped for that. That's not your mandate. So identify local organization in each country where you work that can be your partners and can look into this. Then one important thing, and I think it has been repeated constantly, for us, reprisals and addressing risk of reprisals is not something that we do to protect our complainants. We do it jointly with them. They know better than we do. They tell you what they're seeing, and they must decide for themselves if they're in agreement with the kind of measures we're talking about. That comes, for example, in confidentiality. I have had cases where complainants have prepared not to use confidentiality because they say they feel safer by them posting their name in a website saying that they filed a case with us. Others do not. So that engagement, and at any one point, any risk measures, mitigation measures that you establish have to be done jointly with a community. I'll give some examples. We had a problem of evictions in Argentina, and we had to travel to the site. This was a small state in the north of Argentina where everyone knew each other. And we were booking a hotel that turned out to be a hotel that was owned by the police chief, who was actually harassing this community. Some of our colleagues in the team looked very foreign. So it wasn't a good idea to be taking in a small town someone who was obviously a foreigner. So we engaged with the community. We asked them, where should we be staying? How should we be booking our hotels so we wouldn't have a high profile, but also selecting those in the team that could be passed as locals. And then where could we meet with the community so not to put them in danger? The same happens with communications or with any kind of engagement that you might have with an outreach. You have to ask them. Don't assume that you know the answers. They will help you out. And at the same time, we have to decide if a case processing can continue when situations are so risky that they might be facing violence or strategic cases against them just to withhold from them presenting a complaint. And as I was saying, we are no experts. And I have to confess, I'm not a lawyer, I'm not a human rights expert, I'm an economist that landed up this kind of jobs. So what we have to produce is to be able to check what others are doing. And I have put some resources here, but as I said, I am more than willing to walk you through our experience and give you our examples of what we've done. The Guide for Independent Accountability Mechanisms that establishes measures to address the risk of reprisals is a toolkit that is free and accessible. It's available in English and Spanish. We produce it while my time at NICI, and that walks you through a series of steps. It has templates. It has also organizations you can rely on. It gives you ideas and tips of how you can do this. I have put there the guidelines for addressing risk of reprisals from MISI that also look as an example of how you ensure that your procedures fit the protocol that you have for addressing risk of reprisals. And I have also added here how to address issues related to COVID, because what we're seeing with COVID is basically people because they have to stay at home, they're more easily targeted because they have stay-at-home orders. Communications are being intercepted. At the same time, it's very difficult to continue communication and not be there in person. So we're seeing an increasing number of issues where COVID has risen the level of risk that communities have. And this guide, this was produced by the IFC, is quite sort of comprehensive on different kind of examples that we could have. But we have to be aware. For me, the most important issue on doing this is put yourselves in the shoes of a complainant that is very vulnerable, that has limited resources, and don't think from your office, don't think from the kind of comfort that we have with technology and situations, and try to address as much as you can decision, and be totally transparent and honest when you cannot do certain things, so that they can have an informed decision of how to do next. I have had a wonderful relationship with a number of organizations who have helped us navigate this. And I hope the echo is not very still, but like the Coalition for Human Rights in Development, Human Rights Watch, Protection International, they have trained us, they have helped us find resources. The Office of the Human Rights Commissioner of the Commission for Human Rights is another good option. And I'll stay there so that you can raise questions. I hope this is useful. There's never enough time, and I'm happy to do a workshop on how to try to do these things. No one has the right answer, but certainly at IPAN, we're working to be known to individuals and groups that use IPAN. We produce an outreach strategy that is available in our website so that people know what to expect and what to do. We're trying to ease barriers to access as much as we can and have the resources too, because this is also a limit on the resources that you have. We're operating in looking at how we have to be gender and culturally appropriate and not make assumptions on our situation. Look at how we work on safe access, but also through confidential case handling, and the measures of mitigation and assessment that have to be continuous at different milestones through the case processing. Thank you so much. Thanks for the opportunity, and congratulations on this training. It's very, very useful.
Thank you, Victoria. After we've had such enriching presentations and conversations about practical ways to ensure accessibility and to limit the risks of retaliation, I wanted to provide simply a few design recommendations. As those of you who are still designing or updating your grievance mechanism, what are some good practices that will increase accessibility based on what we've seen from our cases? And while we at Accountability Counsel are bringing the voices of communities impacted by investments to this discussion, I also wanted to note, really hearing as many complaints as possible from communities is good for business too, right? Because communities who are living near or working at investment sites are often going to be the first to know if an investment is going off course or if there's an unintended impact. And if there is an effective, efficient, and trusted channel for those communities to reach up to the investment decision makers, then there's going to be a quicker and easier way to mitigate what the issues are, right? So it's in everybody's best interest to have the mechanism be as accessible as possible. So what I've listed here are a few design recommendations that we suggest when we're talking to institutions who are designing new grievance redress mechanisms, and when we're looking at the policies of the existing accountability mechanisms and trying to make them stronger. In the interest of time, I'm not going to read through all of these because we are able to share our slides, but these are the main recommendations. And then the following slides give some examples of where we see these recommendations in practice at existing mechanisms. So if you're designing your grievance mechanism and you're saying, okay, I'm interested in making sure that materials are translated into local language, how do I put that in a policy? You can see that there's existing policies that have some sample language that you could use. One that I wanted to just spend a little time on is this first one, however, to mandate a public outreach strategy. So as we've heard from prior presentations and in other discussions we've had in the grant partnership, people don't know that grievance mechanisms exist. And one of the main accessibility barriers is just lack of awareness that this is an option. And so as much as we want accountability mechanisms or grievance redress mechanisms to undertake outreach, one thing that can make that really helpful is to actually have that mandated as part of the grievance redress mechanisms, like mandate or part of its strategy. And making that clear will help, convince the institution that you need budget for it, help with the pushback that you might receive if the institution feels like you're out there trying to search for cases, or there's going to be a flood of cases. If you can say, this is part of our mandate, this is something we're supposed to do in order to meet our job and to meet our mandate, that can help kind of mitigate some of that pushback that we've seen. So we've got the translation piece that we've talked about regularly. We also see that some mechanisms actually provide a sample complaint template. As Victoria said, in a perfect world, really, like Accountability Counsel or CL shouldn't be needed to help communities navigate these processes. They should be understandable and accessible to communities on their own. And one way to do that is to provide a template of, this is the information that would be helpful to include. It doesn't have to be so like rigid, but just to give people an idea of what information to send, so that you aren't going with that back and forth to try to make sure whether or not this is a valid complaint or whether or not it's eligible. That can be really helpful. So like I said, on these slides, I just give examples from other existing policies that are good examples of accessible language and like good requirements for accessibility and the design of mechanisms. So I'm just going to click through these kind of quickly here. We can talk about them later if there's any questions. But what I wanted to mention as well is that we have Accountability Counsel, which is a database online that's free and accessible to those that need to use it. And what we do is we benchmark the existing accountability mechanism policies against a bunch of questions about accessibility, transparency, legitimacy, all the effectiveness criteria in the UN guiding principles. And so here's an example of some of the questions that we ask about access. And so we have all of the policies in the database, and we say, does this mechanism issue its own press releases and media communication? Is there information that's available in like national or local offices? Is there a website? So you can kind of check against, as you're designing your own or as you're updating your own, you can see some of the practice that exists out there and kind of compare across mechanisms to further this community of practice. But I'll just thank everybody and say that we are so appreciative of all of the work that everyone on this call is doing. We know from our casework that effective accountability mechanisms can be so transformative and really ensure that investments are sustainable and that the people who bear the most risk when they go off track have their rights protected. And so we're just so thankful for all of the work that this community is doing to make your own mechanisms as effective as possible.